Next, we focus on the standard of care. First, within that, we focus on the reasonably prudent person. That gets us to another really old case from 1837, Vaughton versus Menlove, and it gets us to Ms. Moulton. What was going on in this case? Had you ever heard of a Hey Rick before this case? Neither had I. Yeah, like a Hey Rick. Okay, so what was up with this Hey Rick? Right. Now, here, I'm very amused by the facts of the defendant's conduct. They say to him over and over again, the plaintiff says to him, his friends say to him, hey buddy, this is all going to catch fire. And he basically says in so many words, I'll chance it. Okay. Well, he rolled snake eyes, didn't he? He ends up liable for all of it. And, okay, now, can you tell me what the defense was? It's hard, but I want you to have a go to try to tell me. Because there was a defense in the case. And it's kind of a funny one. Yeah. It's difficult. As I read it, the defendant was basically saying, through counsel I imagine, this guy's too stupid to be careless. He didn't know better. And the court basically says, tough. You caused it. Everybody told you about it. The mere fact that you don't know as much as everybody you live around isn't enough for you to escape liability. And so I found that pretty interesting. But look at page 152. In the first full paragraph, basically what the court is doing is upholding the reasonable person standard. And that's why we're looking at this. Saying, this guy may be too stupid to know the difference, but he's smart enough to stack hay and rich enough to own it. And it's common knowledge that if you put a big pile of hay together, it's going to start to ferment in the middle and it can get hot. And I had a lot of stuff as a city boy from Hollywood. Believe it or not, we had no hay in Hollywood. But he even constructed a flue within it, which meant that he personally could foresee it catching fire. Now, I read a case like this, and I sort of wonder, why didn't he just relocate it 10 yards in the other direction? Why did he have to put it there? And history does not answer that. Also, we see in note 4 that sometime in the 60s or 70s, the legal system realized that women existed as well, and so we have a reasonable person standard rather than a reasonable man standard. And you know, believe it or not, I actually think there is something a little substantial to that. I don't think it's just changing the language to be politically correct, but acknowledging that we will look at the individual case and we will judge the reasonableness of the person based on the facts. So in note 5 we see a struggle to establish what a reasonable person is. And we see that a reasonable person is not average. Because if we talked about an average person, half of the people wouldn't meet the standard. So a reasonable person is more than that, much broader than that. And a reasonable person is not super cautious. Some of us are, especially if we've been in dangerous situations before and we have a similar situation. We might be a lot more cautious than someone with no experience. But for our purposes here, what we're concerned about is reasonable care. And reasonable is a very broad standard and a fairly inclusive standard. And that brings us to the case of Belair versus McAdoo. And Mr. Sather, what do you have to say about this 1936 car versus car accident?
The defendant was, in this case, was trying to pass and he suffered a blowout from what the plaintiff alleged was a defective tire, and so suffered damages.
There was a lot of testimony about this tire, too.
Yes.
What came out about the quality of that tire?
So the plaintiff had people come in and say it was so worn down that you could see the break.
Uh-huh.
And the defense basically contradicted that, saying, no, it's in good shape, but fortunately the jury had to decide to question that.
And there was plenty of testimony from people that saw the tire that said it was no good. And would you agree that the court found that reasonable people know that bad tires are dangerous?
Yeah, they went farther than that. I think they said you have to know.
Right.
Drivers must know. Drivers must be held to the knowledge of, they should, if you're a driver, you gotta make sure that the tires are properly inflated. Yeah, they didn't say that, but you just gotta make sure that they're not always on that.
Right. And they talked about how blowouts are dangerous and commonplace and easily preventable. And so again, this idea of utility versus the harm. Cars are very useful and valuable to have. But you've got to take care of them. And if you don't, you can expect to be found liable for them. Do you think this was getting close to strict liability?
I wouldn't say so. Just because a car is a dangerous thing, but it's still commonplace.
Yeah.
Not reasonably.
Yeah. Now take a look at note 3 at the very bottom of page 154. Are there any facts that every mentally competent adult knows? And there are a number of cases that bring this out. I like the issues presented in note 4 a little better. People who are in unfamiliar circumstances. A city dweller who's never seen a bull and then tries to ride the bull. Personally, I think that's pretty dumb. But legally, is it negligent? Well, that's pretty interesting. Take a look in note 5, a really interesting case. Distinguish ignorance from the breach of duty to find out. A stranger in town is suddenly confronted with a purple traffic light. Then what? And then a landlord-tenant case. An interesting question raised by point 6 is, should skilled people who have extraordinary skills be held to a higher standard of care? And the answer is sometimes yes, particularly if the total pattern of facts suggests that it would be reasonable to do so. Related to that is another landlord-tenant case, and a recent one from New York in 1982, Tremarco versus Klein. Mr. Walker, finally I get to hear your voice tonight, which I assume will be in better shape since you no longer are coughing and miserably sick. Feeling better? Excellent. Well, what was going on here in this Tremarco versus Klein case? Right. Now, the testimony that came out was that this glass was pretty old, wasn't it? And since the time that glass had been installed, it had been much more common for people to use safety glass. Isn't that also true? Now, what did the court have to say about the reasonableness of the defendant's conduct in this case? And so basically, is the plaintiff's evidence good enough to establish liability? Why not? Well, and if you look at the judge's instruction, now looking at very close to the end of the case, the judge is touching on this idea of custom and usage. What was that about? Right. Now, so this idea of standard practice is relevant to establish what a reasonable actor would do. Is that correct? Okay. What if the standard practice in the industry is careless? Is that a defense? Okay, take a look at note 3 at the top of page 159. It asks that exact question. What if the custom of the industry is a careless one? And in the end, the courts are free to overlook that and say, look, you guys are all idiots, and this guy is going to be the example to the rest of you because liability flows. So common custom is relevant. It's admissible, and sometimes it can be persuasive in establishing that the defendant, in fact, has acted reasonably. But it isn't a magic bullet. It doesn't, just establishing what the common practice is doesn't equal a guaranteed defense. Because if the common practice is very careless, that's not good enough. And the courts will step in, even if it means changing the standard of practice throughout an entire industry. Now, a good example is found in note 5. It asks, are there customs that are so clearly unreasonable that they're not even to be admitted as evidence of due care? And they answer yes, and they give a good example. Defendant is operating a mine where there are a lot of holes that people climb ladders up and down through. And the defendant mine company didn't light up these holes and didn't post any guards. All the companies acted that way, and somebody falls through one of these unguarded, unlit holes and is hurt and sues. And the defendant says, well, look, we all do this. And the court says, we're not even going to let you argue that, because what happened here was so ridiculous. Next, I guess we'll touch on one or two more cases before we take a break. Law students throughout the generations get pretty sick of judges who try to write cute decisions. Well, here is Justice Carlin. I don't know if it was Justice George Carlin. Decides that he's going to compose a Shakespearean-style decision. And our authors decided to include it. I see all of you shaking your heads no, and I decided to focus on it in class also. Mr. Wilford, what was going on in this? You need to offer a translation for all of us. Okay, so both the cabbie and the crook abandon this vehicle, and it hits this family. And do you have any sense of how badly they were hurt? Okay, the answer is they were hardly hurt at all. They're hardly hurt at all. If you look at page 162, at the first full paragraph, the court is loath to see the plaintiffs go without recovery, even though their damages were slight. So this mom and her kids were not very badly hurt. Now, I'd suggest if they had been badly hurt, it might have been a somewhat closer case. But what I like in this decision, not that much because of the writing, but if you look at the top of page 161, there is discussion about the plaintiff's brief on reasonable care. Interesting quote, I'll read it. Quote, it is respectfully submitted that the value of the interest of the public at large to be immune from being injured by a dangerous instrumentality as a car, unattended while in motion, is a lot more important than the utility of the person who is exiting the vehicle. I like that because it is framing the argument in terms that we understand from earlier in the chapter. The plaintiff loses this argument. And the court, in its flowery language, basically says, look, an ordinary, reasonable, a man in this case, an ordinary, reasonable person is not an uncommon hero. That's why uncommon heroes are so admired, because most of us are not that good. Now, take a look at the very bottom of page 161, and we see that that emergencies do not require mature judgment. Emergencies require quick action. Now, in the first note about this case at page 162, we're suggested that we ought to compare this case, with Vincent versus Lake Erie Transport at page 123, a case that I very briefly touched on at the very beginning of tonight's presentation. I won't go further on that thread. Take a look at note 2, an interesting little procedural idea. Suppose the defendant is basically saying that there was an emergency and that's their defense. What note 2 tells us is that emergency is not an affirmative defense, even though the defendant has to prove it. Look at note 3. We get a very good definition of a sudden emergency. You know, in Baja California, they've had a big hurricane. That wasn't sudden. They could see it coming. They knew it was about to happen. But to qualify as a sudden emergency, the event has to be unforeseen, sudden, and unexpected. And look at the case of Vasconcelos versus Mills. Blinding effect of setting sun's rays, common, no sudden emergency. But black ice on the street, falling boulders, swooping airplanes, darting children and animals, all sudden emergencies. Note 4. Does the emergency excuse the actor from the standard of reasonable care? And I'd suggest no, it doesn't. But it does color the situation in such a way that certainly affects whether we judge the actor's conduct to be reasonable or not. Look at note 5, and we see an idea, we've seen it before in other contexts. If the defendant caused the emergency, the defendant can't use that emergency as a defense. If the plaintiff caused the emergency, the defendant could use it as a defense, and if some third party caused the emergency, again, also, defense would be available. Now, look at note 6, an interesting question presented. Should the defendant anticipate an emergency? What if the defendant is driving past a school? Should it be reasonable to expect that kids might dart out? I'd suggest yes, and that's probably why there are slower speed limits in front of schools. Next, we'll turn to Roberts versus Louisiana, and then after that, in fact, we will take a break. And I will go back up to Mr. Corbin, and I'll say, what happened to this guy at his trip to the post office? And the blind guy, was he bigger than the old guy? Yeah, pretty substantially bigger. Now, would it be reasonable, as far as you're concerned, to characterize the analysis of the case as asking and answering the question, was it reasonable for the blind guy to leave his cane? So you think it's different than a reasonable blind person? Are you sure that's true? What was the testimony in this case about that? Look at the very bottom of page 164, if you didn't note it. If they're in a familiar setting. So this guy's been working at this concession stand for a long time. He knows his way around. At the top of page 165, we learn about expert witness testimony that was presented, and the plaintiff's expert witness didn't really do very good work here. He didn't even properly test his own theories. And if you look at the last long paragraph, which is on page 165, the court basically finds that what the blind guy did in this case was reasonable. Do you think that's a good decision, or do you disagree with it? Do you think this accident wouldn't have happened if he'd had his cane? I agree with that. I kind of have the same feelings about this case that you did as I was reading. I was thinking, well, you don't like that? What's your thought? Which lady? The person that got hit? That's kind of good. That's a good question. We don't know. Do you think that it's possible that person was careless and got bumped into for being oblivious? Possible. Yes. Right. Right, and you can hear it too. Exactly right. So, that's exactly. It's excellent. This is a great class. I get to just stand here and you make all of my points for me. Right. I look at this case and I think there are plenty of facts that go both ways. But we're focusing on the conduct of the defendant and on whether or not it's reasonable. And what I take away from this case is this court basically looked at the blind guy and judged his conduct to be reasonable. We're not trying to sue the blind guy.
Right, they were trying to get the town blind.
Well, the blind guy was not a party to this action,
Right.
but he was being focused on. In L.A., when I was a young attorney, there were the L.A. County Criminal Courthouse had a concession stand that was run by a blind person. These are fairly common social programs, and I remember watching that person operate and make change. It was really astonishing how skillful and good they were, but I don't remember ever seeing them walk the hallways. Look at the notes at the bottom of page 165, and we see a number of cases that appear to be reasonable handicapped people cases. Question presented in note 2, is a blind person negligent going out alone? And would having a cane or not having a cane make a difference for liability then? Answer probably yes. The authors ask a couple of good questions at the top of page 166 that they don't answer. Number 1, will the reasonable person with a physical disability always exercise more care than one without it? Should it make any difference if the party with a physical disability is a plaintiff or the defendant? I don't have an answer to either of those. But in my experience, a reasonable person with a disability has to exercise more care because their mobility is limited. But I'm sure that their ability to be careless is as good as the rest of us. Look at note 6 for the Americans with Disabilities Act, where the ADA can affect tort law by rendering conduct of the defendant as per se negligent in violating statutes that relate to disabilities. I'm currently working on a class action disability case about autistic children and their parents visiting Disneyland and being mistreated. Very interesting tort civil rights law together. Look at note 7 at page 166. Here we've got the intoxication coming up again. Is voluntary intoxication a disability? Answer no. Involuntary intoxication typically is a defense, and I very much like the quote at the end of note 8, which I will use to close this part of our class. We will take a brief break after I'm finished reading. Quote, 1885, Robinson versus Pioche. A drunken man is as much entitled to a safe street as a sober one, and much more in need of it. Let's take a break of 10 to 13 minutes, and when we get back, we will consider the case of Robinson versus Ritson.